Harry Littman, the United States Supreme Court is getting involved now in some of these cases involving Trump's executive orders. One of the more high-profile ones is this USAID case where Trump cut off all of the funding to USAID and therefore could be leading to massive deaths across the world of people who were relying on this funding to quite literally live. I mean, there were people in experimental life-saving programs who had like things inside of their body and they have to show up at like a doctor's office to deal with, you know, certain types of things that are keeping them alive, and they can't do things like that because USAID programs are not functioning anymore like they used to be, or people who were getting food who could be starving to death. So this is not some hypothetical issue. I mean, we're talking about human being lives that are happening. And so this USAID case was filed by, and there were different ones that were filed, but the big one here was filed to basically get the USAID to continue to fund as it was required to do by Congress. A district court judge agreed with the plaintiffs and basically issued an injunction and then issued another order enforcing it that basically said, Trump administration, Congress appropriated these funds. People are going to die. This is an emergency. You got to pay. I think the judge gave a 36-hour deadline. Trump's administration immediately, emergency basis, went to the Court of Appeals. The Court of Appeals rejected it. They didn't hear it. So then Trump immediately went to the Supreme Court. This is urgent. We do not want to fund USAID. This court's forcing us to fund these people and keep people alive. Basically, let's be clear. Let's call it what it is. We want these people dead. We want them to starve to death. We want the programs shut down because that's the effect of it. Justice John Roberts, we need you to intervene and we need you to issue a stay that would stop the funding from reaching all of the contractors and all of the people from USAID. Justice John Roberts, he, on an emergency basis, stops the district court order. I mean, he stays it is what the legal terminology is. And so he blocks the ability of this funding to reach the places, but orders an expedited emergency briefing schedule. Meanwhile, we'll have to figure out how many people have died or how many people this has impacted as a result of, oh, why don't you submit your brief here and you submit your brief there, and then we'll talk about it. And so now we have this expedited briefing. So Harry, United States Supreme Court on the shadow docket, if you will, with the, you know, they intervened, they blocked the aid from reaching its the final output. What do you make of all this?
Yeah. So first, the way, as you put it, Ben, this is a walking irreparable injury, right? The plaintiffs came in, and February 13th, we're talking 2 weeks ago, the district court entered the order, and this is an order your listeners now are familiar with. To do a stay, it's got to be extra. You have to show you're probably going to win. And as you've pointed out, they showed that, of course, because you can't just ignore Congress, and you have to show that you're facing irreparable injury, and you've spelled it out. It's happening every day. But it gets more interesting from there, because basically over the next 2 weeks, the administration does not a fucking thing, if I can use the French on it, because what happened in that hearing when the judge said you've got 36 hours was he was completely exasperated, and he turned to the department attorney and said, you've given me nothing at all to show that you've tried to comply with this. And the attorney, you know, it's hard to be an attorney in the Trump administration these days. They throw you into court and say, you know, defend us, but it's lawless action, and they're usually not in the know anyway. All this poor sap could say is, well, we're going to address it in the next status conference on the 18th. And the plaintiffs were jumping up and down and screaming, as you say, people are dying. Okay, so it was at that point that the exasperated district court said, you got 36 hours, and all you have to do, all they're talking about now, Ben, it's important, is pay up the money you owed for completed work as of the 13th. Money that the government says, yes, of course, we'll pay when we get around to it. And so then they play the emergency card. And this is something they've done literally 10 times as much as previous administrations. And it's a real game of chicken, because on the one hand, they don't do anything for a couple weeks, but now they come screaming to the Supreme Court saying, we can't possibly comply because it takes all this time to sort of unwind and rewind and get things flowing again. Now, in a normal situation, if this were, I don't know, a student or an employee, you'd say, well, what were you doing these 2 weeks? I don't want to hear it. Go comply. It's trickier, though, for the Supreme Court, because they can say, we don't care what you were doing. Go comply. And if the administration honestly or dishonestly just doesn't do it, now you're in this real loggerheads, the place that everyone's scared what Trump will do. But here's the thing. So the brief comes in now. You're just as you say, Roberts it's not a real solid for the administration. What he said is, okay, we'll look at this very fast, but we need some briefs, and you give this to us in 48 hours. And the brief that comes in is pretty strong, because what it says is, this isn't about vacating a stay. All the district court did was, and this is inherent power in the district court, is do something to enforce its previous order. And they're really not challenging the previous order. At the time, they had plenty of time to deal with it then. They're saying this immediate thing we just can't comply with. But they plaintiffs on the other side actually lead with a jurisdictional argument, and that was the argument that the D.C. Circuit, as you mentioned, they first run to the D.C. Circuit, put out there saying there's no jurisdiction. This is just a district court judge doing something in the service of its own order. So we got a really interesting now situation in the Supreme Court. Do they cut the government a little bit of slack? So it can go anywhere from, on the one hand, they could do as the Court of Appeals said, look, sorry, we don't have jurisdiction here, and don't come complaining to us after doing nothing for 2 weeks. Or they could try to cut them a little slack. I think there'll be some votes for that, just to avoid the kind of complete loggerheads of the administration not doing what they say. But the administration's also set it up, and I just want to make sure your listeners know this, the final asterisk, on the actual substance of it. Because one of the things that you have to do to get a stay is show you're likely to win. And I don't think the government can show that, but there's a possibility that the Supreme Court actually sets up what's going to be one of the, maybe the biggest issue that the Trump administration has served up so far, which is, can they just ignore? Congress does appropriated money. That's what they do under Article 1. And in several situations, the executive branch under Trump has just said, we're not going to do that. Now, that should seem outrageous and the sort of thing that you summarily reverse. But with this Supreme Court, bullish as it is on executive power, and sometimes bullish as it is on Donald Trump, the president, actually honor the idea that you can just ignore Congress. So this case, first, it's totally brazen that and I write about this in my Substack today, they do nothing for 2 weeks, and then they say, oh, well, we can't possibly do it in 36 hours. Of course, they've already had a little bit extra time with the briefing. And the Supreme Court now has it. This is the second emergency application the Trump folks have made. And the first one was totally meritless, but that's their stock in trade. And it creates this mini crisis where, the court is having to worry about, maybe they're right when they say it's an emergency. So now it's served up to that. And I could see the court doing anything from pretty little to pretty big. But I'll just end with the brief again, saying strong argument here that under the law, there's nothing the court can do. This is all between the district court and the administration. If they fail to qualify and follow the orders. So it's contempt, it's whatever. But the district court has already entered its orders, and it's just trying to make sure that they're executed.
So basically, Harry, the Trump administration is creating their own, based on their own negligence or their own failure to comply with the status quo to begin with.
Number one line of the brief. You're good, Ben. The government has got, it's an emergency of its own making. Exactly.
And because they've ginned up the emergency, and now they're saying the status quo has to be preserved, but the government's defining the status quo as the status quo under the emergency they created, versus what the plaintiffs are saying is no. The status quo was you owed the money to people whose contracts were made. You're supposed to pay them.
Or at least it was 2 weeks ago you were ordered to. That's why the Substack title is The Administration That Cries Wolf. But that's right.
Well, everybody got to check it out. It's at the Harry Litman Substack. The Talking Feds Substack is where you go. The Talking Feds YouTube channel is where you subscribe for the videos. And the Talking Feds podcast is where you go for a great podcast. It's where I get my legal news from, and I hope you subscribe to all of them. Talking Feds Substack, Talking Feds YouTube, Talking Feds podcast. Thanks, Harry.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.